If a lawsuit hit your life tomorrow, could it actually take your money, or would it just bounce off your plan? Keep watching, because the next few minutes could save you years of stress. Hi, I'm Kevin, the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. For 34 years, I've helped business owners and investors protect what they've built, and for nearly 30 of those, my team and I have set up more Cook Islands trusts than any firm in the world. And yes, we've seen almost everything, and if you want clear, calm strategies that work in the real world, hit subscribe now if you haven't, so you never miss tools that keep you 2 steps ahead. Let's be honest, you can't outrun a lawsuit. The legal system moves slow, but it has long legs. A process server doesn't care how fast you drive, and the internet doesn't forget. Trying to hide is like covering a lighthouse with a beach towel. It just doesn't work. So here's the real game. You don't outrun, you outsmart. Now, lawsuits are about pressure and leverage. The other side wants to trap your assets so that you'll settle out of fear. They'll use 3 levers. 1, freezing things you own. 2, forcing you to pay to defend yourself. And 3, scaring your family and partners. Now, you flip the game by removing the leverage. When your legal structures turn your assets from easy target into hard target, the math for the attacker often collapses. I'll show you how step by step. Now, in a few minutes, I'll reveal the move that makes debt collectors and contingency fee lawyers walk away without a fight, because they can't get paid. So go ahead and stay for that. Okay, here's the mindset shift from fear to control. Now, fear says, don't move. Maybe it'll pass. Control says, position first, then you can sleep. Now, when a storm is coming, smart captains don't argue with the weather. They tie down the ship. Asset protection is the same. We don't play hide and seek. We build structures that are legal, visible, boring, and yet very hard to reach. Simple truth. Lawsuits attack weak structures, not strong ones. A strong structure is like a car with airbags, seat belts, and anti-lock brakes. You still drive, but you're ready if somebody swerves into your lane. Quick example. A physician owned rentals in his personal name. One small injury claim turned into a 7-figure lawsuit. So we restructured each property in its own land trust. An LLC is the beneficiary of each land trust for protection. We recorded liens to strip the excess equity, and cash was moved into protected accounts. Now, the tone of the case totally changed. Why? Because the money was no longer sitting in a bowl on the table. Okay, now let's look under the hood how lawsuits really work. Let's take the mystery out of lawsuits in plain English. Now, filing a lawsuit is cheap. Winning is hard. Collecting is hard, and we want to make it even harder for them. Now, lawyers chase assets that are easy to grab. Cash in your name, equity in property that you own, business interests. Without blockers, this can be easy to take. If your wealth sits in one bucket, your name, it's low-hanging fruit. If your wealth lives inside the right legal containers, the path to grab it becomes long, expensive, and uncertain. So we use 3 layers. Separation. Your operating company, your real estate, your personal savings, each sits in its own bucket. Shields, LLCs, and trusts, they're not magic, they're guardrails with teeth. Next, friction. Proper liens, charging order protection, and when appropriate, offshore law that U.S. judges don't control. This is legal. This is normal. We're not hiding. We're positioning. In a moment, I'll explain the structure where you keep control when life is calm, and the moment somebody sues, control shifts just enough to make your assets untouchable. It's elegant. Okay, here's the elegant move, keeping control when the fight arrives. Now, here's the structure we use for serious protection. A trust in the Cook Islands, or Belize. Cook Islands is in the South Pacific. It's just due south of Hawaii. In fact, it's in the same time zone as Hawaii. Or Belize, which is in Central America. We also use Nevis, which is southeast of Florida. Those 3 jurisdictions have the most powerful trust trust laws in the world. Okay, let's talk about the Cook Islands Trust plus an LLC inside of it. We make you, the client, the manager of that LLC when seas are calm. Our licensed, bonded, trusted company law firm stands by with a simple rule. They only step in when needed, when a lawsuit strikes or a court tries to reach your assets. So what would you rather have? A 100% chance of the courts taking your money, or a licensed, bonded law firm, trustee, in the most regulated trust jurisdiction in the world, with your reputation that goes back, in our case, 30 years, who has never taken a client's money, do what you've paid them to do. So why the Cook Islands? First, because their asset protection law is built for this specifically. A creditor must file in the Cook Islands under Cook Islands law with a high standard of proof and short time windows. U.S. judgments aren't simply enforced there. In plain English, a U.S. lawyer can't just wave a piece of paper and take your money overseas. Okay, control versus protection. Now, day to day, you run the LLC like normal investments, account instructions to your banks. If trouble hits, however, you stop being the pilot and become the passenger. Because if you were the pilot, the judge could force you to fly the plane into your opponent's lap. So the trustee temporarily takes the controls and follows the trust rules, which says protect the client, obey the law of the trust, don't send the money where a court can grab it. When the storm passes, control goes back to you. Here's a composite case study. This is an entrepreneur who sold a software company, and he parked 7 figures in a U.S. brokerage account and got hit with a lawsuit from a former partner. So we moved the liquid assets under a Cook Islands Trust with a Cook Islands LLC custodian. In fact, we moved the brokerage account. We didn't even sell the stock. We just did a transfer in kind of the stock to a Swiss brokerage house. So the banks in Switzerland are also the brokerage houses. So we didn't sell the stock. We just did a broker-to-broker transfer. So it was not a taxable event. So again, we set up a Cook Islands Trust with a Cook Islands LLC inside of it, leaving the client as the manager initially. Now, when litigation escalated, the trustee stepped in as manager of the LLC to keep the funds out of the reach of the U.S. courts, and the case settled for pennies on the dollar. No hiding, just structure. Here's the cliffhanger solved. That's the move that makes the contingency fee lawyers step back. So they realize the pot of gold is not on the other side of the ocean, not under their rules and not under their timeline. Okay, now let's talk about real estate, turning equity into armor. If you own property, listen closely, because real estate is lawsuit catnip because it's public and it looks rich on paper. Now here's the fix. Title each property in a separate land trust with an LLC as the beneficiary of that land trust. Each property in its own land trust, each land trust has an LLC separate as a beneficiary. So you have the liability cubbyhole and the privacy of the land trust. So if one property has a problem, the others don't bleed. Strip excess equity with properly documented liens. Record mortgages or deeds of trust so there's nothing fat to grab. So why do we do it like this? Because the paper shows debt where you used to look wide open. For US-based real estate, the offshore trust doesn't take title. Instead, we use equity stripping notes initially payable to the LLC owned by your offshore trust. And then if needed, a third-party lender can purchase those notes and the proceeds rest safely within the structure. You still own and control your properties day to day, but the equity is no longer an easy target because we stripped away the equity and put away the proceeds into your offshore trust outside the reach of the U.S. courts. Next, you want to keep clean books. Commingling kills cases. Composite example. There was a family with 5 rentals. They had $3.2 million in equity across properties held in one LLC. One tenant injury turned nasty. So we retitled 5 LLCs, each with its own bank account, recorded mortgages to the right size equity, and moved cash reserves under the offshore trust LLC combo. So the plaintiff's counsel went from we'll take the buildings to maybe we can talk. So that's leverage shifting. Okay, here's the cliffhanger. But Kevin, what if a judge says, bring the money back? We'll hold that thought and we'll cover that repatriation order thing in a moment. Okay, next up, your operating company, make it slippery. Yes, I know, a different shirt, a different day. Your operating company should be strong on the inside and slippery on the outside. Inside strength, signed contracts, clear terms, no handshake myths. Good insurance, yes, still get it. Insurance pays lawyers and settlements. Structure stops worst case outcomes. Procedures, incident reports, camera systems, trainings, Juries love paper and video. Outside slipperiness, use a manager-managed LLC or corporation for the operating business, and then keep your personal name off of vendor deals when possible. Also, I strongly recommend to many of my clients to consider a holding company that owns the operating company. Sued? The holding company stays out of reach. Keep excess cash out of the operating company. Accounts pay the bills. Wealth lives in protected structures. When you have equipment, you hold the equipment in one company, and the operating company that deals with customer signs contracts and has the liability simply leases the equipment from the other company. That way, when the main business gets sued, there's very little to nothing to take. Common myth to kill? I have an LLC, so I'm safe. Well, not if you treat it like a piggy bank. Follow formalities, separate accounts, real minutes when needed, real payroll, real lease agreements, even if you own the building, personally or through another entity. This is simple stuff, and it wins cases that you never see because cases don't get filed when you look tight. Okay, the bring it back question. Okay, the big fear, what if a judge orders me to bring the money back from my offshore trust? Here's the key. The trust, not you, owns the offshore LLC inside of it and the offshore accounts. When things are calm, you manage the LLC and give instructions. If litigation strikes, the independent Cook Islands Trustee Company law firm takes the helm. The trustee is not subject to U.S. court orders. They follow the law of the trust, which says protect you. Your job is to be cooperative, disclose the structure, be honest and do not lie. Our job is to design it so that even in full daylight, it still works. So we don't rely on secrecy. We rely on the rule of law, just the right law. So think of it like a safety lock on a power tool. You can't accidentally turn it on. During the storm, your finger is off the trigger. When the storm clears, you're back in control. Okay, here's the cliffhanger resolved. That's why repatriation orders often fail against this structure. In fact, it's fail every time in our case. The client doesn't control the money during the emergency. The trust does, legally and ethically. Okay, now let's talk about timing, the moment that matters. The best time to build a roof is before the rain. Every jurisdiction has rules about moving assets after you know there's a claim. So move early, clean, and for real business reasons. Estate planning, risk separation, and wealth management. When you set it up before trouble, the structure speaks for itself. When you wait until sirens are blaring, you shrink your options. If you're already in a dispute, don't freeze, get real advice fast. Sometimes the right steps are still available, and sometimes we pair a Belize or Cook Islands Trust with an immediate equity strip. The point is to act with counsel, not panic with Google. Okay, here's what to protect first. Priorities help. Here's a simple order of operations. Cash and brokerage account. Think about it. That's what the lawyers want most. That's the easiest to get and to give to their client. Move significant liquid funds under the trust LLC structure. That's the honeypot that attackers really want. Next, real estate equity. Right size it with liens and proper titling. Keep each property in its own bucket. Separate land trust owned by a separate LLC. Operating company. Tighten contracts, update insurance, and move extra cash out of the company. Retirement accounts. Many already have protection under federal or state law, so don't break that. Coordinate, don't collide. Okay, toys and trophies. Boats, fees. Visible assets attract lawsuits. So title them wisely or quarantine them in their own entities. Here's an action tip. Pick one thing to do this week. Open the dedicated bank accounts for your LLCs. Give us a call so we can help you. Or start the paperwork for your Cook Islands Trust. Again, visit assetprotectionplanners.com. Get a lot of free information there. Momentum beats perfection. Okay, let me give you some real stories and real results. Composite story A, contractor chaos. A contractor signed a personally guaranteed lease for equipment. Job delays hit. The vendor sued for the full balance, tried to freeze the contractor's account. Because the personal cash lived under a Cook Islands Trust LLC structure and the operating company kept only working capital, the freeze attempt fell flat. They settled for a fraction on terms that fit the business. The company lived to fight another day. Here's composite story B, the medical practice. A small medical practice faced a malpractice claim and a billing audit at the same time. Now, before the storm, the doctor had contacted us and had separated the building from the practice, equity stripped the property, and moved investment accounts offshore under a Cook Islands Trust. Now, the claim dragged on, as claims do, but the family's wealth sat outside the fight. Doctors kept practicing, the kids stayed in school, and that's the win that no headline will ever show. Here's composite story C, the real estate family. Mom and Dad owned 7 rentals and a small commercial building, and everything was in one bucket. So we moved each property into its own LLC, placed recorded mortgages to right-size the equity, and put the reserves under the Offshore Trust LLC combo. A slip and fall claim later happened. The plaintiff's counsel looked, shrugged, and negotiated. Quiet protection is still protection. Okay, so what is this not? Let's be crystal clear. Asset protection is not tax evasion, not secrecy, and not magic words. So we follow the law. We file what's needed to be filed. We give honest answers. We build structure that works in light, not just in the dark. So if anybody sells you a hide the money trick, real planning does not need tricks. Okay, it started raining, so I had to move in out of the rain. Now here's your 7-step checklist. Here's a clean checklist you can screenshot. First, inventory your world. Companies, properties, accounts, debts, and personal guarantees. Decide buckets: operating company, real estate holding company, and asset holding company, and personal wealth entity. Next, establish formalities. Separate bank accounts, bookkeeping, and basic minutes where needed. Build your offshore core, the Offshore Cook Islands Trust or Belize Trust with an LLC inside of it. It's an offshore LLC that you manage in calm seas, and then a licensed bonded trustee company law firm steps in during the storms to protect you. Deflate visible equity. So we record mortgages, notes to right-size your property equity, and we actually help you find mortgage for your particular solution. We have mortgage entities around the country that can help you strip the equity from your property and give you the cash. Consider third-party note buyers where appropriate, and that's where we can help. Insure the risks. Good general liability, umbrella, malpractice, or E&O where needed. Insurance pays the fight. Structure wins the war. So don't wait. Start before trouble. If you're already in it, get help. In fact, I just came in out of the storm because I would have gotten soaked, and I want you to come in out of the legal storm so you don't get soaked financially. So get help today, not tomorrow. Now, if this was helpful, go ahead and subscribe so you stay ahead of the next curve. And when you're ready to stop worrying about lawsuits and start sleeping better, go to assetprotectionplanners.com. My team and I will listen, map your risks, and show you exactly how to lock it all down, because you deserve to keep control of what you've built. And here's a closing thought. You can't outrun a lawsuit, but you can outsmart it. When your money sits behind the right walls, the fear melts. You get your evenings back, your spouse sleeps, your kids stop asking, "Are we okay?" Because the answer is yes. You made it hard to take what you built, and that's what smart wealth feels like. Thanks for watching.